A request to split their ongoing counterclaim into two distinct cases was denied, dealing LIV Golf another legal blow in their ongoing dispute with the PGA Tour. Since their formation in the summer of 2022, LIV has been engaged in a conflict with the PGA Tour. 10 months after the first tournament of the Saudi-backed series, the PGA Tour decided to ban any player who chose to compete on the breakaway circuit. Since then, the relationship between the two adversaries has deteriorated, as both parties have filed lawsuits against each other in court. In response to an antitrust complaint filed by LIV Golf against the PGA Tour, the latter has asserted that the Public Investment Fund of the Kingdom of Saudi Arabia, the PIF, and Yasser Al Rumayyan possess evidence, including emails from players and broadcasters that could support their defense and counterclaim against Greg Norman et al. In an attempt to expedite the initial complaint, LIV believes that the lawsuit should be divided into two distinct cases. Wednesday, however, Judge Beth Lapson Freeman denied the request in a 4-page order issued by the U.S. District Court for the Northern District of California. Judge Freeman said the court notes that the tour has shown that its counterclaims and plaintiffs' antitrust claims will likely involve overlapping facts and evidence. When there is a factual overlap between claims, courts are reluctant to separate the proceedings. This is the most recent setback to the breakaway circuit in recent weeks. This follows the DP World Tour's legal victory against LIV Golf last Thursday. The Wentworth-based circuit's decision to impose financial sanctions and tournament suspensions against LIV members was upheld, as confirmed by Sport Resolutions. Sport Resolutions said in a statement, the appeal panel ultimately found that the appellants committed serious breaches of the code of behavior of the DPWT regulations by playing in the LIV Golf Invitational in London and LIV Portland events respectively, despite their release requests having been refused. The appeals were dismissed, and each of the appellants were ordered to pay the fine of £100,000 originally imposed. The most recent courtroom development in the LIV PGA Tour dispute may portend trouble for the Saudi-backed upstarts. A federal judge ruled on Thursday night that PGA Tour attorneys may depose the Saudi Public Investment Fund, including PIF Governor Yasser Al Rumayyan, for documents relating to the fund and its role as LIV Golf's primary financier. Al Rumayyan and the PIF had sought protection from the tour's legal investigations, which threatened to unearth information about the highly secretive fund on the basis of sovereign immunity, an argument Judge Susan Van Keulen rejected. Al Rumayyan and the PIF sought exemption under the Foreign Sovereign Immunities Act, a 1976 statute that defines the roles of U.S. courts in litigation against foreign nations and foreign citizens. With a few exceptions, foreign agents are immune from the jurisdiction of U.S. courts under the FSIA, including when conducting commercial activity within the United States. In the months leading up to Thursday's ruling, attorneys for LIV, Al Rumayyan, and the PIF argued that the fund was merely an investor in LIV and not a business associate, meaning that the PIF did not engage in commercial activity in the United States. The ruling, which was issued by the U.S. District Court for the Northern District of California, rejected these arguments and stated that Al Rumayyan and the PIF were the moving force behind the founding, funding, oversight, and operation of LIV, and were thus not exempt from the tour's depositions. The ruling could be a turning point in the ongoing legal dispute between LIV and the tour regarding the tour's alleged monopoly status. If Al Rumayyan and the PIF consent to the depositions, the tour attorneys could subpoena truckloads of documents from the PIF and Al Rumayyan, shedding light on the actions and motivations of the clandestine government-owned fund in golf and beyond. If the two parties fail to cooperate with the deposition, they could be held in contempt of court, which could have severe repercussions for LIV's standing before the court. A third option would be for LIV to withdraw the lawsuit entirely, ending litigation and any prospect of legal discovery that could alter LIV's standing with the tour, which has indefinitely suspended its players. According to a report by ESPN, attorneys for LIV and PIF will ask a different federal judge, Beth Lapson Freeman, to review Van Keulen's ruling. Golf enthusiasts may recall Lapson Freeman's name. 3 LIV golfers, Taylor Gooch, Hudson Swafford, and Matt Jones, were deemed ineligible to compete in the FedEx Cup playoffs by this judge in the summer of 2017. So that's all for today's video. If you enjoyed it, remember to leave a like, subscribe, and ring that bell icon so that you never miss our upcoming videos. And don't forget to share your thoughts in the comments section down below. Stay tuned, and we'll catch you in the next video.